And everyone has now drastically gone to see what's happened to their sound. Good morning, everybody. It's just gone 10 o'clock, and it's time for us to do one of our first webinars in this month of Transport Month. I see the government refers to OTM, and I keep trying to work out what's this OTM, one-time management, but October Transport Month. Welcome. Thank you for joining us. Today, we're going to talk about AARTO. When we looked this morning, just before we started live with you, we had already 80 registrations, and they are coming in as we go along. So thank you for putting aside about an hour to listen to our two esteemed and experienced presenters and to hear what they have to say. And what we've done is we've selected specific topics out of AARTO, not the whole shooting match. And obviously, if you have other questions relating to AARTO or other issues that you might have, we can deal with those later on in the month, or you can just get those through to us. So first of all, what are we going to do today? We're going to have two presenters, and we're going to have two specific topics. We will do questions after each presentation. So I'd like to ask that you keep those presentations. You can type them and send them through to us, or we can ask the questions after the presentation. During the presentations, please make sure that your mics are turned off and that your videos are turned off. That allows some people who have bandwidth or connectivity issues to actually be able to enjoy the whole webinar. The session is being recorded, so if you fall asleep halfway through, which I hope you won't do, but if you'd like to go back to it a little bit later and hear what was discussed and maybe then work through it and then have a question or two, you will be able to get it off the RFA website. And of course, you can always send any of your queries or questions to the RFA at inquiries@rfa.co.za. So the first speaker up this morning is Jaden Kramer. No relation to David Kramer, but Jaden did say he can sing a bit. Jaden is an associate in the employment law practice with Cliff Decker Hofmeyer. He has lots of experience in infrastructure, transport, and logistics industries, and he has done a lot of advisors and papers in terms of various employment law aspects. So this is the guy that knows what AARTO is going to do in terms of employment and what we should be doing and how we should be looking at it. He's also done a lot of interdicting in terms of unprotected strikes, and thank goodness we didn't have a strike this time in the transport industry. That's 13 years, ladies and gents, of no strikes. Picketing, he doesn't do the picketing, he does interdicts in terms of picketing, and then breach of restraints in terms of trade, business transfers, and retrenchments. So, Jaden, it's over to you, sir.
Thanks so much, Gavin, and thanks for the warm welcome. It's an honor and a privilege always to speak to the RFA. And yeah, good news about the strikes, and hopefully there won't be any after my presentation either. So today, as Gavin mentioned, what we'll be doing is I will be addressing the employment law aspects of what we're talking about today, and then Kwazi will come in and talk more about the practicalities, the demerit system, how that all works, and the like. So I'm not going to go too much into the technicalities on that side. I'll mainly just stick to the employment side of things and how we deal with our contracts, our policies, and managing our employees through this time. So as you can see, I'll be talking about changing contract clauses and how we deal with that. So I assume everyone can see my presentation. So what I want to kick off by saying, and I hope Kwazi won't be too offended when I say this, but unfortunately, the Act is not particularly well drafted piece of legislation. It often, when I read it, it presents more problems than it solves from a practical side of things. And often what I find is that, particularly in this industry, we struggle to kind of marry the legislation with the practicalities and how we deal with that. And perhaps Kwazi will touch more on how that's going to be addressed through the practical aspects. But what I'm going to stick to is now just how we address that from an employment law perspective and how we manage these issues going from our employees. So just a bit of background before I begin. We can see here that the intention of AARTO is really to promote road traffic equality by providing for a scheme that discourages road traffic contraventions and facilitates the efficient adjudication of road traffic infringements. Now, we can see that technically it was signed on the 13th of August 2019, still not fully operational, but it looks like it's getting there. And perhaps Kwasi will also address us a little bit more on that. Before the introduction of AARTO, what happened was we dealt with all of these kind of offences in terms of the Criminal Procedure Act. And the Criminal Procedure Act was followed as you would, you go through the courts and the like, and that was legislated in that way. AARTO introduces this new term of an infringement, which really means any act or omission in contravention of the act, so AARTO, and any road traffic legislation or transport legislation. So it's quite a broad category that has now been included into the infringement side of things. If we also look at what that means practically, it means that out of the same set of facts, one could be charged with both an offence and an infringement, and we'll have to look at how we deal with that. And we look at section 24(1) of the Act. Any person who is committed or is deemed to have committed an offence or an infringement incurs the prescribed number of demerit points, and there's the schedule. Kwasi will perhaps take us through that as well. In terms of section 24(3), if a person commits 2 or more infringements, demerit points are recorded only in relation to the infringement with a greater number of demerit points. So that's quite important to just pay attention to. So while there's a split between offences and infringements, when you commit more than one infringement, only the more serious infringement will apply. And there's also another split when it comes to whether you will be dealing with a demerit against a particular driver or a particular vehicle. You can incur demerit points against both in respect of one infringement. Now, really what we are here to talk about, and what I'm here to talk about from an employment law perspective, is how we deal with what we see in section 25 of AARTO, which deals with the prohibition on driving or operating a motor vehicle once a person, operator, or a juristic person who is not an operator incurs the maximum number of demerits and essentially then has a license suspended. So what I'm really going to be talking about is these 3 topics here today. So how do we deal with this? Is it an incapacity? Is it misconduct? Where do we deal with recruitment and disclosure, and how do we deal with it? And then I'll touch a little bit on the insurance aspects, as those often come into play, and we've advised clients quite a lot on that, and it does seem to be something that many people are quite worried about. So straight into incapacity or misconduct. So one of the most serious implications of AARTO in the employment sphere relates to the disqualification of a driver for a period of time. Drivers are appointed on the basis that they have the requisite driver's license and that they are able to drive the vehicle that conveys the company's product. If these drivers are disqualified from driving, then they're unable to fulfill a material term of their contract of employment. Now, I'll get to this a bit later, but one of the main things that we'll have to include in our contracts of employment, if it isn't already there, is that drivers will have to have a valid driver's license, and that needs to be a contractual term, and I'll talk about why that becomes important in a minute. So going back, in circumstances where a driver is unable to fulfill his or her contractual obligations, the company will have to consider whether it is appropriate to terminate that driver's employment or whether it would be a suspension. Now, both of these instances will have to follow the correct procedure and a fair procedure, and I'll also talk about that. But really what we need to ensure is that from a commercial point of view and from a legal point of view, that employees are protected when going through this process. I'll also just mention that in terms of recovering contributions during a period of suspension, there is going to be a bit of contention there. So, for example, when a driver is suspended, we can't just stop all contributions, for example, as Provident Fund, because this would be in contravention of that particular piece of legislation and opens the company up to imprisonment and even a fine where they've contravened Section 13 Cap A of the Pension Fund Act. So it's quite important that those contributions don't stop. But what we've thought about and advised clients of in the past is that when an employer suspends an employee, for example, in this situation, what we could do is we then carry on with the basic contributions. So the principle of no work, no pay will apply during the suspension. The contributions will continue being paid. And then what we'll have is a Section 34 deduction, and that's in terms of the Basic Conditions of Employment Act. This requires consent, and it's a bit of a process, and you have to stick to the strict application of the Basic Conditions of Employment Act when trying to recover these. But essentially, what will happen is that when an employee is suspended, their contributions will continue. When they come back to work, they'll receive their salary, and then we'll recoup the funds back from the employee going forward. Obviously, in strict compliance with the Basic Conditions of Employment Act. That was just a bit of a side note, but just going back to the main concern, the basis for termination, depending on the circumstances, and again, I think this is something that we'll talk about a little bit more when we get into the more practical side of things, but we really have to decide whether this is going to be a form of misconduct, incapacity, or even by operation of law. Now, what we've often advised clients and what we think is the safest thing to do would be to move completely away from any kind of performance or incapacity situation and move away from this. So performance would be, for example, where someone can't do something, and what we're saying is this is a case of will not do something, and we'll talk a little bit more about what I mean exactly there. In addition to what's been covered there, we must also consider that a driver's conduct, even in his personal capacity with his personal license and his personal vehicle, can now have a direct impact on his employment. So that's also something that we'll have to keep in mind. And in our case law, there is a distinction, and there are cases that deal with acts of misconduct, essentially, that almost affect the employment relationship. What we want to do is move away from that by including the requirement that you have a valid driver's license in your contract of employment. And if we do that, then it takes us back into the employment sphere, even when the act that led to the disqualification arose in your personal capacity. And then lastly, when going through this entire process, I think employers will also have to bring in their own commercial requirements. I mean, it's expensive to train drivers, especially particularly where, for example, they're transporting hazardous waste or something that requires an additional level of training. So I think those would also be commercial concerns that we can also get into, but really that would be the background to the law. Now, the second point that I briefly want to touch on is the recruitment and disclosure. And obviously, as it seems all things do, it seems as if we're going to start off with the buzzword, which is POPI, and protection of personal information does, unfortunately, or fortunately, depending on how you view it, come to the fore here. So it comes in as early as the interview and appointment stage, and this is for obvious reasons. When you're appointing a driver, you would like to know how many demerits they currently have they gone through a rehabilitation program, all of those kind of questions that you would want to kind of get to grips with before you appoint someone as a driver. So this would include, for example, having reference checks, criminal record checks, and the like. I think Kwazi might talk about how and when we'll be able to access those demerit points and the like, but I won't talk about that too much. Just really to bring to the conversation that this would have to be done in terms of our legislation, particularly POPI, and it would be something that we would have to consider. So basically, what I'm saying here is it just adds an additional level of scrutiny that would have to be applied, and the scrutiny would have to be applied within the confines of the Protection of Personal Information Act. Another point that I'd like to bring up here is that this disclosure is not a disclosure that ends at the recruitment phase. What we have envisioned and what we would import into the contracts is that the disclosure would be an ongoing and continuous disclosure. So as soon as a driver receives a demerit or license is suspended or any kind of impact or change to their status as a driver, that should immediately be brought to the employer's attention, and that should be something that is specifically contracted into your terms and conditions of employment, that as soon as there's a material change to your status, you need to bring that straight to the attention of your employer. And for example, this would be in the case where a driver is set to go out on a long haul. They've got a very important client that they're delivering to. You wouldn't necessarily want to send a driver who's one demerit point away from having their license suspended, or who potentially has their license suspended, but they haven't taken the time to go and check that their license is suspended. So those would be the kind of practicalities that the disclosure element would provide for. And then obviously it would be a dismissible offense where an employee or applicant for employment makes a false representation or fails to disclose any kind of relevant information. So those are the two topics, or the first two topics rather. Going back to the three topics, insurance. Again, I think I just want to briefly touch on this because it will have implications, as insurers are sure to take into consideration any demerit points earned by drivers, operators, the company, all of these kind of elements, which will probably be linked to some kind of underwriting criterion because it directly reflects not only driver behavior, but it could be used to assess whether a company has a particularly high level of drivers whose licenses are being suspended or incurring demerit points and the like. So it's just something that we would like to bring to your attention, as this would or could result in higher insurance premiums or even repudiation of claims in certain instances where there's been non-disclosure and the like. So there is quite a bit of consideration that needs to go into that aspect. Now, I guess really what I'm here to mainly speak about is the practical side of things, disciplinary action and the like. So from a practical side, a major consideration for any employer pursuant to reading this act would be to amend their disciplinary code and procedure, as well as their contracts of employment to cater for the situations that we've been discussing. So to take, for example, a non-disclosure, what we would suggest is that the contracts of employment, as I've suggested, be specifically amended to include an ongoing disclosure clause. Any change to the driver status needs to be included, and any change to their demerit points will need to be brought to the employer's attention immediately. And when an employee fails to disclose his or her demerit points, the status of his points, the license, or any other information that materially affects his ability to perform, his or her ability to perform, or even places the employer at some kind of risk for cancellation of a contract or the like, that would be something that immediately has to be brought to the attention of the employer. When it comes to demerit points, and I touched on it a bit earlier, is that we'd have to distinguish between demerits that are accrued in your personal capacity and your personal license and while not performing your duties, and where you have accrued demerit points in terms of a vehicle that is a company vehicle while performing your duties and therefore in the course and scope of your employment. So those two need to be kind of divorced. And as I've mentioned, if you amend your contracts correctly, then we can still keep both of those in the employment sphere. Then there's also a further consideration is when an employee receives demerit points in his professional capacity. This could also be, or their license is suspended. This could also result from receiving a demerit point against a particular vehicle, and this would also have to be considered in light of whether the employee knew or reasonably could have known about the particular let's say defect that caused the demerit point. And these are kind of considerations that we'd have to take into consideration when we make any of our decisions, and that would be the decision to suspend, decision to dismiss, and the like. So what we would do is there would be a process whereby, because it's linked to a contract of employment, the employee's license is suspended. They immediately go on suspension themselves as they're in breach of their contract of employment. They will receive no work, no pay, and then the sanction to be dealt will depend honestly on the facts and what's been put forward. And I'll get into how we deal with that and why. But what I want to do is start off that topic with a case, an incarceration case. And we find that the incarceration cases kind of give us a bit of insight into how the courts might handle these situations. So there's the Samancor case, as you can see there, where an employee was arrested and held in police custody on suspicion of armed robbery. After 6 months, the employer decided that they couldn't take it anymore. They sent a letter dismissing the employee. 4 months later, the employee was released, and there was some kind of what they've termed a confirmation hearing. Now, the confirmation hearing went ahead, and they confirmed the decision to dismiss. So the arbitrator and the Labour Court found that the dismissal was both procedurally and substantively unfair. It went all the way to the Labour Appeal Court, and the Labour Appeal Court differed from the previous findings and really stated that the employee was dismissed after 6 months of absence by the employer who had no way of knowing when the employee would be released. Now, obviously, we can separate this from the situation of AARTO, where you would normally have a suspension and you would know there would be a finite period. But the rest of the points are equally as important or more important to the AARTO context, in that the court found that the employer had very specific and valid operational requirements that needed the employee to be able to perform his duties in terms of his contract of employment. They couldn't be expected to wait for an indefinite period of time, and the employee's arrest basically incapacitated the employee, and that incapacity does not only relate to ill health. So as I spoke a bit about, incapacity in the ordinary sense is normally limited to performance and ill health, but really what we're talking about now is almost a misconduct incapacity. For these reasons, the court ultimately found that it was substantively fair. The dismissal was substantively fair. Where we need to address the case in our context is that they found it was procedurally unfair. And this was because of the process that was followed. This dismissal after 6 months, and then this confirmation hearing, which doesn't necessarily bring us in line with the principle of audi alteram partem, and item 4 of Schedule 8 of the Code of Good Practice, which you'll find reads with the LRA. So what we need to do is we have regard to this item 4 of Schedule 8, and item 4 of Schedule 8 basically says that in terms of this process, and when going through this process, we need to understand that an investigation would have to be done, that there has to be some kind of inquiry, but it specifically says that this doesn't have to be a formal inquiry. So the basic points or topics that we kind of need to hit when it comes to this is that the employer should notify the employee of the allegations in a format that the employee understands and can reasonably understand. The employee needs to be given a chance to prepare and respond. Representation is also allowed. And then this needs to go before an independent chairperson who communicates the decision that was ultimately taken. So what we can do here is we say that AARTO has presented us with a particular employment set of circumstances, almost unique. And what we need to do is we need to amend our policies and our contracts of employment to allow for almost an expedited procedure. We can't have situations where an employee is suspended, license is suspended for 3 months, and it takes a month or 2 months to get through the hearing. That's just not a tenable situation, and it's something we want to try and avoid and fast track. So what do? We have a written submission process whereby the employer says, this is what the situation is. Your license has been suspended. The employee will then have a chance to respond. Reasonable time, 48 hours. That's generally considered to be a reasonable time to respond. And then both of these submissions get submitted to a independent chairperson who will make a finding. So obviously this is a simpler process than most, because it's quite a factual dispute, in that most of the facts will be common cause, and it would just be for the arbitrator or the chairperson to decide how they want to handle it. Are there any aggravating or mitigating circumstances? So really importantly, what we want to try to do is have an expedited procedure that complies with the principle of audi alteram partem. That is, both sides of the story needs to be heard, and once both of these have been complied with, we can go ahead and make the finding that we would want. Depending on the circumstances, for example, when it's not the employee's fault, it might be a lesser sanction, for example, a final written warning or even a written warning, and you can deal with that in your codes. But really what we want to ensure is that there is an expedited process that will be followed in terms of these codes. Now, the last point, so we've addressed all the legalities, we've addressed the act, but we're still left with the operational requirements of the business. And importantly, what we're looking at here is almost a gap. So the employee has now been suspended, no work, no pay applies, so the company is protected in that aspect, but we still have the one key element, which is the operational requirements to consider. So something that we've been looking at and advising clients on is that we can have a special kind of fixed term contract that will come into play. And this fixed term contract will be specifically linked to the suspended employee. So there, in terms of our LRA, we are allowed to have a fixed term contract for justifiable reasons. And the justifiable reason would be that it was linked to a particular employee's suspension. And it will last for that finite period. And once the employee comes back, the fixed term contract terminates. So really, that's what I'm going to discuss today. I'll now hand over to Kwazi, who will take us a little bit more into the technicalities, and that might open up more of a discussion. But for now, that's my side of things. Thank you.
Thank you very much, Jaden. And there's a reason why we're recording this, because wow, there were a lot of facts in there. And even I'm going to go back and listen to that a couple of times to make sure that I've also got all of these important milestones in place. I haven't seen any questions for your presentation, but as I say, it was quite loaded with a lot of information. I'm sure a lot of people are going to go back and digest that. But once again, thank you very much. Some very, very pertinent points. One of the big things is exactly what do you do once your employees or your drivers are going to get to whatever level of points you set in your business, and what do you do when they exceed the threshold, whatever that threshold might be. Right, let's move on to Kwazi Ngobo. Kwazi Ngobo is with the RTIA, the Road Traffic Infringement Authority, and he's now going to do the next presentation. Kwazi is the manager in charge of representations, authorization of enforcement orders, the revocation of those enforcement orders, which is the job we hope he does very well, revoke all of them, and the points demerit system functions within the RTIA. So Kwazi's got a lot of those, I think it was said at NEDLAC, hot potatoes that he's going to have to deal with and find solutions for. He's got 19 years of working experience in transport, so he has got a good, solid background. He understands transport, and that's been at a provincial and in the national sphere as well. Without any further ado, Kwazi, over to you. Thank you very much.
Thank you very much, Gavin, and good morning, ladies and gentlemen. I would like to switch off my video because it seems like my bandwidth quality is not good, Chair. I think it would be better maybe if I switch off my video while doing this presentation, if that is not a problem. Okay, all right. Okay, my video will focus on my presentation. It will focus on key aspects of the points demerit system. But must inform everyone that the points demerit system is not yet implemented. It will only be implemented when the proclamation is done by the president. Hopefully sometime next year, around July. The minister pronounced that the 1st of July next year is the date that is planning for the point demerit system and the rehabilitation program to be implemented throughout the country. So my presentation will touch on the introduction of the points demerit system, the implications, how are the points calculated, to whom is it applicable to, how are the points incurred, how are they reduced, disqualification period, cancellation, operator implications, then general matters, and then questions and answers. The point demerit system is part of the wider traffic law sanctioning system. The PDS assign points to drivers or owners of vehicle when committed traffic violations. If within a certain period collected points exceed a specific limit, extra sanctions like prohibition from driving will be imposed in addition to regular monetary sanctions. But I will deal with that one when I'm talking about the disqualification part of this presentation. The aim of the points demerit system is not to victimize drivers, but is to discourage drivers and prevent them from offending or re-offending or infringing in a traffic environment. So it's like it's supposed to be a preventative measure so that people don't end up committing violations, which end up leading to a lot of fatalities on our roads. For those who repeatedly commit traffic violations, PDS will result in a temporary ban from driving. It is temporary because even if your license end up being cancelled, after a certain period of time, you can be able to apply for a new one and be back on the road again. So there is nowhere in terms of the AARTO Act where you will be permanently prohibited from driving. Whether you are cancelled or suspended, there will be a time where if you put some effort, you'll be allowed to drive again. So how is this going to assist this points demerit system? So it'll make it easier to identify habitual offenders or infringers. We hope that it will increase compliance with road traffic laws, because no one would like to lose his or her licenses. So we think that this stick of AARTO will encourage people to drive in a manner that is in line with the road traffic laws. Then eventually, it is anticipated that there will be safer roads and improved driver behavior, reduction of crashes, serious injuries, which eventually, most of the time, leads to road fatalities. Persons disqualified from driving, person can be disqualified from driving and licenses can be cancelled. But for those who violate the rules of the road, not for everyone. How are these points calculated? We'll all start at 0, and the points, like the first presenter mentioned, the points are based on the level of traffic violation as per Schedule 3 of the AARTO regulations. That schedule, that is where we have all the traffic violations listed, aligned with the National Road Traffic Act, as well as the Cross-Border Act, as well as the NLTA. So we have that Schedule 3 with all the violations and the monetary value linked to those violations, as well as demerit points. So the points are added to record of a person, whether it's a heuristic person or a natural person. The points will diminish over time. 1 point every 3 months will diminish or be reduced. Points will also be reduced upon successful completion of a rehabilitation program. The points will be applicable to all persons. Points are recorded against the record of a person, the ID number. Chapter 4 of the AARTO Act refers to a person. Demerit points are allocated to learner drivers, persons without licenses as well as foreign drivers. One will ask, but how are you going to deal with people without South African licenses? Yes, there will be points allocated to those people, because even if you don't have a license, a record of a person can be introduced on natives, meaning that if you are using a license that maybe one of the SADC licenses, but they are not on natives, but as long as you have exceeded that 15 points threshold, you will not be allowed to drive, because in terms of the act will be prohibited. But unfortunately, we don't have powers to cancel licenses from other countries. And if the license has been cancelled, points will still be added. The infringements may have been issued already at the time of cancellation of the license. The Act does not provide for non-allocation of points, whether the document has been suspended or cancelled. But if a person continues to commit violations that carry demerit points, those points will continue to be added. Meaning that if you are prohibited from driving, you can end up having a prolonged prohibition period if one continue to commit violations. If disqualified from driving, the person will be charged and the points will be allocated if that person continue to commit traffic violation. And carrying of points. Some infringements and offenses will carry points. It's not all of them that will carry points. The way that the draft schedule 3 was created, it was just focusing on the main causes of fatalities on our road. So if you go through the schedule, you'll see that it's not all violations that carry points, but it will be those that are more related to the causes of accidents and deaths and serious injuries on our roads. Only when someone is paid or that person applied for installment and it was accepted by the RTIA, or when an enforcement order is issued, or when a person is found guilty, that is only when the points will be allocated. It's not, doesn't mean that as soon as you receive the infringement, then the points will be allocated. No, only when paid, acceptance of installment, when an enforcement order is issued, guilty in court. An enforcement order is a third document in the AARTO process. You have an infringement notice. If you don't do anything after 32 days, there's a cancellation letter. If you don't do anything, then after that, there will be an enforcement order. So it's only when it has reached that phase, and if a person did not do anything, that the points will be allocated. To be added on the actual date of payment or date when the enforcement order was authorized or the installment arrangement was accepted or the date found guilty in court. The first presenter did mention that it's very important to note that in case of 2 or more traffic violations in the same case or under the same circumstances, points will only be allocated for the violation with the highest point value. If someone is found drunk and driving, and that person was not wearing a seatbelt, drunken driving will carry about 6 points. So just making an example, maybe the seatbelt can carry about 3 demerit points. But if found guilty in court for drunken driving, and also the person maybe admit guilt for not wearing a seatbelt as well, does not mean that that person will be allocated 9 points, but the point, the violation with the highest point value is the one that the demerit points will be allocated. Which means if that person found guilty in court and then only 6 points for that drunken driving offense will be allocated instead of 9 points. If the court decision has been appealed, points should be kept in suspense pending the finalization of the appeal. And the reduction of points, in terms of Section 28 of the AARTO Act, 1 point will be reduced every 3 months. And the points will always be reduced without suspension of this 1 point every 3 months. Even if it's after cancellation, the same principle will apply even if the MSc cancels the license. The same principle will apply as well. But there's also a rehabilitation program, of which I'm not going to dwell on it so much, but just to touch on it briefly. This is a program whereby a person can attend maybe for a week or so. It can be voluntary. Can also attend it even if one driving license or document is cancelled or suspended. Once the rehabilitation program is attended and you completed it, 4 demerit points will be reduced. So let's say you have already accumulated more than 15 points, you are maybe on 17 points. That means it's a 6 months suspension because you are 2 points above 15. But if you attend a rehabilitation program, which maybe will be for a week or so, you can have 4 points being reduced, then you can be back to 13 and be allowed to drive again. This rehabilitation program maybe can be a program that focuses on the behavior on the driver, something like a refresher maybe course about the rules of the road and how someone is supposed to behave on the road. But I'm not going to touch on this so much because the programs that will be available, they are still not yet communicated with the members of the public. So I'm not going to dwell on this one so much. I've already touched on the disqualification period. 3 months for every point above 15. For example, if you are on 17, that means it will be 2 points more than 15, and you multiply that one by 3. Then we have 6 months suspension if you have 17 points. But if you attend rehabilitation program, of which you can only attend once a year, and can have those points being reduced within a short period of time, because the government is taking into consideration that a license for most people is like a qualification, especially for people who are appointed or employed as drivers. If you lose a license and you cannot use your license, then you can end up having a situation, like it was explained by the first presenter, that you can end up maybe losing your job. So that's why there's this rehabilitation program as well. So when the points are at 15 or lower, then a person can be allowed to drive again. The infringer must be notified in a prescribed manner of the suspension. And if there's an enforcement order, and that enforcement order is revoked, also the actions, like this action of disqualifying a document, it will have to be reversed. Cancellation, again, if disqualified 3 times, let's say you have exceeded these 15 points about 3 times, you were suspended, then you have gone back to 15, you can drive again, and end up being suspended. And this suspension happens like 3 times. All the documents will be cancelled. All the documents for that driver will be cancelled 20 days after the date on which the notification of cancellation was served or presumed served. If the license is cancelled, disqualification period is 3 continuous month for every point above 15. The person keep points against his or her record. Also here, if the enforcement order is revoked, all actions will be reversed. With regard to operators and heuristic persons, it's very important that operators and heuristic persons, they keep an updated record on who is driving which vehicle when. It's very important so that operators of fleet management companies can be able to nominate a person in control of the vehicle. There's a form that is used to nominate, but also currently RTIA does allow fleet owners to register and be able to nominate online. So there's that option as well, other than completing forms all the time. But it's very important to nominate, because if you don't nominate, then the points can end up being allocated to that heuristic person. And the manner that is allocated to a heuristic person is quite different from the one that is happening with the natural person. As a heuristic person, you cannot touch that person. It's an organization, but it owns property, it owns vehicles. So the regulations, the draft regulations stating that each vehicle that is owned by this heuristic person also have a threshold of 15 points. If these 15 points are exceeded, then that vehicle will be prohibited from operating. So it's very important that as fleet management companies or operators or heuristic person, very important that make sure that your vehicles are roadworthy, and then make sure that you keep a proper record of your drivers, who was driving, when is that person, does he or she have the right documents to drive a vehicle of a certain class, and be able to nominate. So if the records are proper and the driver has the correct documents and the vehicle is roadworthy, there can be less challenges for fleet owners. The infringements for vehicle roadworthiness will create operator infringements. So it's linked to what I was saying earlier, that it's very important for the vehicles to be roadworthy, because these operator infringements, some of them will also carry demerit points. Operators will be held responsible for vehicle-related infringements. Points incurred will be allocated to vehicles. Once the points threshold exceeded, vehicles will be suspended from operating. So that is very, very important. General, motorists must always keep their records up to date. Suspended licenses and operator card will impact on operations. First presenter did mention that, and they even went into details on how to mitigate those issues. PDS will impact on labor, business relations, which was covered by the first presenter. Payment of fines on behalf of drivers. If the company is paying fines on behalf of drivers, must be very careful about this one, because now it means that if you pay for me as your driver, demerit points will be allocated to me. So it's better before you pay for any infringement that's your driver or it's on your driver's name, you first get his or her consent. Because it might think that you're assisting a person, but a person end up having his license cancelled or suspended caused by that payment. Maybe he was going to apply for a representation or a revocation for that. So it's very important to engage with the drivers before you pay for their traffic fines. Drivers' permission must be sought again to access their demerit points. Cannot access someone's personal information without their consent, especially now that we have POPI. Again, the Act does allow the employer to complete a form to access demerit points, but with the consent from the employee. It is RTIA is planned to make sure that this process, there should be a way of automating it rather than completing forms all the time. All entities must have accurate record management system so that they know exactly who was driving which vehicle, when, was the vehicle licensed or not, and all of that. So there's a lot of role players in this AARTO environment or the point demerit system environment. We have the representation officers, enforcement order officers, and in future might have demerit points officers within the RTIA to deal with AARTO-related matters from the members of the public and the motorists. We have the justice system, because we still have violations that will be offenses. We have issuing authorities, they will issue the AARTO 1s and AARTO 03s and AARTO 02s infringement notices, perform law enforcement functions. You have the NRTOR, the National Road Traffic Offences Register, where all the information regarding violations will be stored. You have the Minister of Transport with all the other powers that are stemming from the legislation, such as making regulations and other powers that are there. You have the board, you have the register, you have the post office for serving documents, you have the banks for collecting payments and other shops that will be collecting payments as well. So, and we have RTIA organization that is a custodian of this AARTO Act. So, very important that all these role players, the motorist as well, the motorist, key role player here, the motorist as well. So it's very important that these role players, all of them, they do whatever that they are supposed to do in line with the legislation in order for this act or for the object of this act to be achieved, in order to ensure that there's a reduction in road accident and fatalities, because currently the situation is not good as far as road safety is concerned. We have about 14,000 people dying on our roads on a yearly basis. And this, we are not saying is the silver bullet for all those problems, but we are saying it's one of the interventions that the government thinks it will assist to intervene in the current situation where you have a lot of people dying on our roads. Thank you very much, ladies and gentlemen. That is the end of my presentation. Thank you.
Thank you very much, Kwazi. Once again, packed full of information, and it's a good thing that we are recording it so people can go back and listen to it step by step. There are 4 questions so far, and I'm going to go through them, and I'll ask you a question, and if you can just answer it, and then we'll move on to the next one. So the first question we had from one of our guests is, if the license is cancelled, is this then only requiring a reapplication, or is it a retest?
Okay. If it's cancelled, it's a retest. It's a retest, but the rehabilitation program, in terms of the current draft regulations, one can attend that program at any time, but you can only attend it once a year. Then upon completion, 4 points will be reduced. But let's say you attend this rehabilitation while you are already cancelled and you are on 17 points. 4 points will be reduced to 13, but doesn't mean that you can go back and drive. You still have to apply or do a retest in order for you to be allowed to drive again.
Right, thanks, Kwazi. I think that answered it. So if your license is cancelled, you are then going to have to go through the whole process of learner's license and then redo the practical driver license test.
Correct.
Thank you. Right, next question. I understand the allocations of demerits to a driver, but the vehicle demerited, who are those points allocated to? The vehicle.
Yes. The points, actually, they are the points that are allocated to a heuristic person. But remember, the points are there to make some sort of an impact or to discourage unlawfulness. So if you just allocate these points to a heuristic person without any implications, then it will defeat the purpose of the system. So these points, they are allocated to a heuristic person in the form of vehicles, whereby each vehicle, if that violation is committed using that vehicle, the points is allocated to a vehicle with a threshold of 15 points. Then maybe a follow-up question will be, what if I sell this vehicle to someone else? What happens to these points? According to the draft regulations, that when you sell this vehicle, it does not go with the points. Points will remain with the heuristic person, and then the next vehicle to be registered, these points will be allocated to that vehicle. So the points will always be with the heuristic person, but for the purpose of ensuring that these points, they make an impact, then they are allocated to a vehicle. There were regulations that were published in 2008. They had a situation whereby if you have a number of vehicles, there's maybe a number of points that you have, and then maybe if I can just give an example, let's say maybe you have 12 vehicles. Those regulations will say you will have about 144 points. Then once you exceed those 144 points, the whole fleet will be suspended. And that it was viewed as a system that will not work or will have harsh consequences for business. So with the draft regulations, that was adjusted to focus on each vehicle that commits violation, so that you don't end up having a situation whereby the whole fleet is suspended and you won't be able to operate. Thank you.
Thanks, Kwazi. Yeah, that was one of the points we've been lobbying for quite some time, and we're quite happy that the Minister of Transport of the RTIA accepted that point. We've come to 11 o'clock, but I'm going to go through the 4 questions that are here, if we can get through them as quickly as possible. And once again, if people on the webinar can't stay, we are recording it, so it will be available on the RFA website. Don't worry about that. So the next question is there a reason why an individual is only allowed 1 rehabilitation opportunity per year?
Yes. The reason, ladies and gentlemen, is to avoid the situation whereby this rehabilitation program is abused by those who can afford to pay for it. Because right now you have a situation whereby people who can afford to pay for traffic fines, they are in a better position than people who don't afford, because they can just pay and continue driving, whereas the person who cannot afford to pay can end up having a warrant of arrest. So now the system is trying to balance between the poor and the rich as far as that one is concerned, whereby whether you are rich or poor, or you can afford to pay for a traffic fine or not, but there must be consequences for the behavior that is not in line with the law. But if the government come with a rehabilitation program that you can just do willy-nilly every time that you are suspended, it will break, or it will hamper the purpose of the points demerit system, because you'll have those with money just attending for a week and back on the road continue to commit violations again. So it's better to do it once, then twice, then just follow the normal of 1 point every 3 months. Thanks.
Thanks, Kwazi. I think what you said in one way answers some of the questions that I'm sure that many of our attendees have seen, where we've said that, we haven't necessarily said, but we've raised the concern that the RTIA through the point demerit system could just be a money-making thing. So I suppose that's an interesting point, excuse the pun, that you can only do this once because it's about changing behavior. The next question, there's a question from one of the guests asking, has or will the RFA engage with representative unions concerning amendment and addendums of employment contracts concerning AARTO? The short answer to that is yes, we have been doing that for a number of years and we continue to do that. And obviously once the final regulations come out, we will do that. Another question for Kwazi, will all fines have contact details and banking details for payment? We travel over the whole country and even cross-border, and that could be a major problem to get them paid.
Yeah. Okay. Currently, there are no banking details on the AARTO fines. What happens is that one can pay online using the infringement notice number. And then if you're making an online payment, they only need the infringement notice number, then it will be linked to our bank account. You don't have to like add a beneficiary or something like that. And if you are paying maybe a walk-in in a bank as well, or any retail shops that are taking payments, or even post office, you don't have to complete any deposit slip with banking details. As long as you have that infringement notice number, that is what you will always use to make AARTO payments. No need for banking details. On the contacts numbers are there. The call center number is there on the traffic fine for more clarifications on other matters pertaining to the whole process. Thank you.
Thanks, Kwazi. Next question. Does the AARTO implementation not make a case for renewal of license card obsolete, or at least to increase the duration for 10 years? I don't know if you can answer that. That's probably a question we can raise with the Minister of Transport. I don't know if you want to make a comment.
My connection is not good, Gavin, but I can see the question here.
Oh, now he's gone.
Yes. Sorry, Gavin, my network is not good, but I can see the question: does the AARTO implementation not make case for renewal of license card obsolete, at least to increase the duration to 10 years? Yeah, I'll just come out clean with this one, ladies and gentlemen. The RTIA only deals with traffic violations. The issue of the period to renew licenses, that one is something that is in the hands of, can say, is the National Department of Transport, because they are the custodian of the National Road Traffic Act. So I'm sorry, I won't be able to do justice or to answer this question.
That's fine, Kwazi. We've got two last questions, and I can see people are starting to leave. The two last questions. The first one is, what is the procedure if a vehicle is suspended, and how long is it suspended after exceeding, obviously, the threshold? That's the first question. And the second question is, who gets the demerits if a driver gets caught with an overload?
Yeah, okay. Let me start with the one if a driver is caught with an overload. Here you will have maybe a traffic officer stopping the driver, or maybe somewhere in a way bridge. An infringement notice will be issued to this driver. This infringement notice, it will have the details of the driver. But when it's captured by the issuing authority or the traffic department, there's another infringement notice that will be created by the system. They call it the AARTO 03. It's an operator infringement. It's like an infringement for punishing the owner to allow the driver to operate a vehicle that is overloaded. So both the driver, the employee, and the owner, the employer, they will get to, each will get an infringement notice, because it's like a dual responsibility. There is a driver not allowed to drive a vehicle that is not allowed to be driven on the road, and as an owner, again, you are not supposed to have a situation whereby you can force people to do that without facing any consequences. So if there are demerit points allocated to that violation, both the driver and the employer, they will incur demerit points. And what is the procedure if the vehicle is suspended, and how long it's suspended after exceeding a point? After exceeding a point, again, the vehicle is suspended for 3 months. And the draft regulations are also anticipating a rehabilitation program, but there's a debate about the rehabilitation program pertaining to a vehicle, because really, who are you rehabilitating? So it's not like a behavior of a person, but safe way to answer this, because there were comments as well around this. Safe way to answer this is that there is 3 months suspension for each point exceeded, even for the vehicle as well. Thank you, Kevin.
Thanks so much, Kwazi. If there are any other questions, please do post them, get them through to us. I'm sure Kwazi or the RTIA will be quite happy to answer those questions. Please remember, we do have regular contact with the RTIA. Just really now for me to thank both Jaden and Kwazi for the presentations. As I said, this will be saved on the RFA website where you'll be able to go and get it. And to everyone who spent the morning with us, thank you for joining us. Have a safe day, stay safe, drive safely, and we'll see you at the next webinar or at our next event. Have a safe Transport Month. Thank you very much, everybody. Goodbye.
Thank you.
Thank you. Thanks, everyone.